I will just tell you a story to give you a concrete sense of why this general framework is unsustainable and why adhering to this framework is very likely to undermine the legal protections that have been put in place so far for girls. So the anti-FGM laws that exist in various countries are at risk of being struck down, as indeed in the United States just last year, the year before, our federal FGM law was ruled unconstitutional. And it actually has to do with common stereotypes about what people think FGM is and what they think male circumcision is. So one last big picture comment, and then I'll just tell you the story, and it will illustrate why it's important to get more specific than these broad brushed characterizations. The big picture story is that when people think of female genital cutting or mutilation, they almost invariably are thinking of the most extreme forms of such cutting that are concentrated in parts of Northeast Africa. And the versions that are held up in the Western consciousness through media and activism are forms that are done in rural villages with unsterilized equipment and so forth. And so they take that form of female genital cutting and they compare it with something like perhaps male circumcision as it's done in Judaism or in Islam, or as it's done in the United States, let's say in a hospital environment. And so when you compare these two things, these are obviously very different from each other. But what most people don't realize, as I alluded to before, is that in that very same African village, if you want to use that example, I mean, these procedures are also done in hospitals in Egypt, for example, by doctors. But let's just use the stereotype of the rural village and the rusty razor blades. Well, in that same village, the boys are also undergoing circumcision with the same rusty razor blades. And so depending on the community, what's done to the boys or to the girls may be more severe or may involve removing more tissue and poses a greater or lesser risk of an infection, amputation of the organ, death, and so forth. And so if you want to make the comparison, the last thing you should be doing is comparing the most extreme form of female genital cutting in a select area of underdeveloped African community with male circumcision as it's performed in a completely different cultural context in a clinical environment. What you should do is you should compare the rural form of female genital cutting with the rural form of male genital cutting, in which case the overlaps are extremely substantial. And if you want to compare medicalized minor genital cutting, you should look to a country like Malaysia, where the girls have a prick to the clitoral hood performed without removal of tissue, done usually by a doctor in a clinical context. It may be done with pain control and so on. So that starts to look a little bit more like what's done in the United States. So in Malaysia, in some Muslim communities, both boys and girls are, on their view, circumcised. And in that case, what's done to the girls is less severe than what's done to the boys. So you have to compare apples to apples, not apples to oranges. But let me just tell you the story. So in the United States, we recently had a federal court case concerning the first federal test of our anti-FGM law. And it concerned a group of Muslims that are known as the Dawoodi Bohra. And this is a religious sect within the Shia branch of Islam. The Dawoodi Bohra are mostly based in India and Pakistan, but they have immigrated all over the world and have different communities in England and the United States. And this particular case was happening in Detroit, in Michigan. So the form of cutting that was alleged to have happened in this case was what's sometimes called a ritual nick or a prick. So the World Health Organization typology of what they call female genital mutilation refers to more than a dozen different practices that have all been conflated under this one term. And then the most extreme form is the one that people use as the illustration of the entire set of practices. But that's very misleading, because in this particular community, it was a physician trained in the United States who's a member of the Dawoodi Bohra, who allegedly cut, or there's some contestation about whether any tissue was removed, but if there was, there was no evidence of tissue removal. Girls around the age of 7 years old as part of what they regard as a religious requirement. So I'm going to talk about religious significance and so forth, but the point here is that within this particular community, there's a tradition according to which Muhammad's innovation over the old Abrahamic covenant in Judaism, where only the boys are allowed to be circumcised, is that to extend the central covenant of the group to include girls Girls were also allowed to be circumcised, but it was instructed by Muhammad, and this is recorded in various hadith, which are secondary sources of Islamic jurisprudence, that what should be done to the girls is very minor and should be less severe than what's done to the boys. And so that is, in fact, the current situation among the Dawoodi Bohra. It's also true, as I mentioned, among some Muslim groups in Malaysia and Indonesia, in some other parts of the world that are outside of the African context, which is what most people are thinking about. So, so this case went up before a judge who could very well see that the ritual pricking of the daughters in this community, done by a doctor for religious reasons, was less severe than the circumcising of sons done within the very same community. This is a Jewish judge named Bernard Friedman, who had previously ruled over some cases to do with defending male circumcision, and it's undoubted that he connected the dots and could see that if he ruled that this particular action counted as a federal crime and would lead to, more than a decade in prison for the members of the Dawoodi Bohra, this would have some pretty uncomfortable implications for the Equal Protection Clause of the Constitution, which says that people, regardless of their sex and gender and their religion, have to be treated equally before the law. Now, he didn't rule on the basis of equal protection. He made a very clever argument to avoid that topic altogether. And I'll just briefly summarize what he said. He said that this form of ritual nicking of the clitoral hood, which doesn't remove tissue, was already illegal at the level of the individual states because it is a form of criminal assault. So he says the federal government in the United States, because it has a system whereby the National Congress cannot make laws affecting the individual states unless it's under very specific circumstances, like if the practice affects interstate commerce or something like that. He said the federal government didn't have the authority to pass this nationwide law banning FGM because it covers procedures that are even less severe than male circumcision, but those procedures are already illegal as criminal assault. So he avoided dealing with the equal protection issue at the federal level, although he has language in the ruling suggesting that he was aware of that issue. He's passed the issue down to the states, but kind of boxed things into a corner here, because if ritual nicking for explicitly religious reasons constitutes criminal assault, then it's hard to see how a more invasive procedure on boys done for the same religious reasons within the same group isn't also a criminal assault. So that is now an unresolved issue in American legal jurisprudence. And this is very likely to affect legal interpretations in other countries. In fact, in England in 2015, there was a ruling by Sir James Munby, who's the senior family judge, considering actually a very similar case, a case where what was alleged to have happened was a form of genital mutilation to a girl. They couldn't find any evidence that any cutting had occurred, which doesn't mean it didn't occur, but it means that if it did occur, it would have been sufficiently superficial that any injury healed completely with no visible sign of change. And he said this same family, because she has a brother, will undoubtedly have also performed genital cutting on the brother, which will be, on any view, much more invasive than what is alleged to have happened to the sister. And he says this creates a problem for our law in England because currently we at least act as though the male procedure is tolerable and is permissible. And we don't only say it's permissible when it's done for religious reasons, by the way. We don't require that there be any particular reason. We just say as long as the parents consent to it or give their permission for it to be done, in England, we treat this as a legal procedure. But an emerging view among some legal theorists is that any cutting of a child's body, if it's not a medically necessary surgery that can't be delayed because they can't consent to it, is an assault. That's the definition of assault. So this is where things are now. And what's happening is those who want to defend male circumcision are putting arguments into the literature in bioethics journals, in mainstream law journals, to argue that, in fact, we should tolerate what they regard as minor forms of female genital mutilation, because they have put two and two together. They see that if there's a zero tolerance policy for FGM, including forms that are less severe than male circumcision, and which may indeed be done for explicitly religious reasons, then the next conclusion is that male circumcision would have to be restricted. They don't want that. And then, credit to them for being consistent in their intellectual arguments. They're now actively and robustly arguing in the bioethics and legal journals that what we should do is allow what they think of as minor female genital cutting, including something as severe as cutting the labia, labiaplasty, or procedures which remove part of the clitoral foreskin. Now, my own view is that even a little prick to the clitoral hood is a morally impermissible practice because you're concentrating surgical risk on a particular part of the girl's body that is constructed as private and personal in almost any culture, and certainly in Western societies. So in Western societies, we have the view, and we teach children from a very young age, that adults shouldn't even touch their genitals unless it's somebody in a caretaking relationship and it's medically necessary. So if you're changing diapers or something like that. But if you continued to wash a child's genitals when they were capable of doing that by themselves, everyone would understand that that was impermissible. But of course, any cutting, even a nick, is far more severe than mere touching. And so in a healthcare context, a doctor certainly should not be taking a surgical instrument to a child's healthy genitals, and certainly not as a way of doing some sort of cultural brokerage with the family. That's not the job of the doctor. The doctor's sole commitment is to the health of the child and has to consider whether the patient is able to consent. So this is a vast conversation that's happening among experts in this area that the public remains almost entirely ignorant of, because they're stuck with these stereotypes from the 1970s, where they think what FGM is rural villages and rusty razor blades, and what they think male circumcision is whatever's done in the US in hospitals or maybe in a synagogue in Judaism. And they don't think about it very much more than that. They've also been told since the 1970s that these practices have completely incomparable reasons and motives between them, which is not true from an anthropological perspective, but it's a sort of an article of faith in the Western discourse. And so when people think of comparing what they have imagined in their heads to be completely incomparable practices, it feels very offensive, and they get agitated and they suggest we shouldn't do it. But my argument is we must compare these practices because they are objectively comparable, and people who know that are making arguments that we should tolerate female circumcision. And so if you want to get ahead of those arguments, which are now gaining steam in the legal literature for the sake of just consistency, which is required by the law, then you're going to have to come up with arguments that are superior to those arguments. And that's what I'm trying to do in my own work, is coming up with an argument saying that all children, regardless of their sexual characteristics, and even intersex children who have genitals that are indeterminate between male and female, all of them deserve to have this special part of their body protected from any surgical risk, because it's rational to prefer that no sharp instrument be taken to that part of your body unless you judge that it's worth the risks, because you endorse the outcome, because you think that on religious or cultural grounds what you're going to benefit from the procedure is worth the risks. So that's a preview of some stuff that we'll get to later.